Hello, my name is Ann Rudolph and I'm a shareholder at the law firm in San Diego of Hughes and Pizzuto. I'm going to talk to you today about the role of court-appointed attorneys in conservatorship cases. This is a short presentation, so I will be unable to cover these issues in depth or cover all possible scenarios, but my goal today is to provide you with the framework needed to understand that your role as a court-appointed attorney is as a zealous advocate for your client's interests, not as a reporter to the court. It is not the role of an attorney to decide what they think is in the best interests of the client and report that to the court. I encourage you to sign up for the panel or list in your county to serve as a court-appointed attorney in conservatorship cases. Your service will be appreciated by the judges and you will gain invaluable experience while at the same time assisting clients who may have nobody else advocating for them because everybody around them thinks they know what's best for them. In those cases, the role of the court-appointed attorney is critical to ensure that a person's wishes are heard and considered by a judge who is tasked with making rulings that may result in the loss of the client's rights of free will to make their own decisions. Some judges will ask you to be a reporter and tell the judge what you think is in your client's best interests. Resist that request. Maintain your role as a zealous advocate for your client's stated wishes. The statutes governing the appointment of a court-appointed attorney in conservatorship cases are Probate Code sections 1470 and 1470.1. Depending on the circumstances, the appointment may be discretionary with the judge or it may be mandatory. However, under both statutes, the standard is that the appointment would be helpful to the resolution of the matter or is necessary to protect the person's interests. Once you have been appointed, the duties of a court-appointed attorney are determined by statute, case law, and local court rules. As a court-appointed attorney, your duty to be a confidential advocate for your client is made clear by thinking of it as a four-sided box. The first side of the box is Business and Professions Code 6068E. Section 6068E provides a clear mandate which requires the attorney, quote, to maintain inviolate the confidence and at every peril to himself or herself to preserve the secrets of his or her client, end quote. The only exception attorney has, but is not required to do, is to reveal a client's confidence if the disclosure is necessary to prevent a criminal act that may result in death or great bodily injury. The next side of the box is Flatt versus Superior Court, 1994, 9 Cal 4th 275. In Flatt, the California Supreme Court stated as follows, quote, it is also an attorney's duty to protect his client in every possible way, and it is a violation of that duty for him to assume a position adverse or antagonistic to his client without the latter's free and intelligent consent given after full knowledge of all the facts and circumstances. By virtue of this role, an attorney is precluded from assuming any relation which would prevent him from devoting his entire energies to his client's interests, nor does it matter that the intention and motives of the attorney are honest. The third side of the box is California Rule of Professional Conduct 1.2, titled Scope of Representation and Allocation of Authority. Rule 1.2, paragraph A, provides that a lawyer shall abide by a client's decisions concerning the objectives of representation and shall reasonably consult with the client as to the means by which they are to be pursued. Comment 1 to Rule 1.2 provides that, quote, paragraph A confers upon the client the ultimate authority to determine the purposes to be served by legal representation within the limits imposed by law and the lawyer's professional obligations. The last side of the box is the Conservatorship of John L., 2010, 48 Cal 4th 131. In the John L. case, the California Supreme Court stated that, quote, like all lawyers, the court-appointed attorney is obligated to keep her client fully informed about the proceedings at hand, to advise the client of his rights, and to vigorously advocate on his behalf, end quote. In addition, the court stated the appointed attorney has a duty to perform in an effective and professional manner. These authorities make it clear the attorney's role is to zealously advocate for the client's interest as directed by the client. You cannot get out of this box. If your client could communicate their wishes, then you must advocate for those interests. If your client cannot communicate their wishes, such as they are in a coma, then you can have no client and you should request to be discharged. In those cases, the judge should appoint a guardian ad litem to report to the court. Whether a proposed conservatee has diminished capacity does not obviate your role as a zealous advocate of your client's interests. Every other state besides California has adopted ABA Model Rule 1.14 or a version of Model Rule 1.14. Model Rule 1.14 allows an attorney to take action to protect a client who the attorney reasonably believes has diminished capacity and is at risk of physical or financial harm if no action is taken. In appropriate cases, the attorney under Model Rule 1.14 can even seek the appointment of a guardian ad litem, a conservator, or a guardian for their client. California attorneys have no similar ability to take protective action for clients with diminished capacity. In 2018, the California Supreme Court approved new rules of professional conduct. They were presented with 70 proposed rules, including a version of Rule 1.14. The only proposed rule the Supreme Court rejected completely was proposed Rule 1.14. The primary reason for the rejection was that Rule 1.14 conflicts with the attorney's duty of confidentiality under Business and Professions Code 6068E. Thus, by rejecting a version of Rule 1.14 in California, the Supreme Court has confirmed that an attorney's role, even for a client with diminished capacity, is to be a zealous advocate for that client. After meeting your client and investigating their circumstances, you may come to believe that your client really is not capable of managing their own affairs and they need a conservator. You may believe your client is incapacitated, that they're subject to undue influence and/or being taken advantage of by a friend or family member, or even that the client is the victim of elder abuse. However, unless your client authorizes you to disclose their confidential communications, you cannot tell the judge what your client has told you. Your client is entitled to have you present their stated wishes to the judge. Without that, then there is no due process for your client. Please don't think that if you properly perform your role as an advocate for your client's stated wishes and don't tell the judge that you believe your client really does need a conservator, then you may be putting your client in harm's way. There are other means available for the court to determine whether the client's wishes are misguided rather than through their own attorney. There are several players in a conservatorship case. The petitioner, who is the person who filed the action before the court. That person has the burden to provide evidence to support the request that the court impose a conservatorship. There is a court investigator who is an employee of the court and an agent of the judge tasked with doing an independent investigation and reporting to the judge. The court investigator will interview the proposed conservatee, the petitioner, and any other necessary friends, relatives, and medical professionals. A conservatorship cannot be ordered without the proposed conservatee being evaluated by a doctor and the filing of a judicial council form capacity declaration, which sets out the proposed conservatee's deficits, if any. In many cases, more than one capacity declaration is filed. In some cases, the court will also appoint a guardian ad litem to assist with determining what's in the best interest of the proposed conservatee. The judge is to consider all of this evidence along with the evidence you present as an advocate for the proposed conservatee as determined by your client. It is the judge who decides whether a conservatorship is necessary. In conclusion, it can be a rewarding experience to serve as a court-appointed attorney. You will have the opportunity to represent interesting clients and assist them in an important role. These are people who may find themselves the subject of involuntary proceedings intended to take away their rights to make decisions for themselves about how they live, where they live, and how they handle their money. These clients, like all clients, are entitled to have a zealous advocate representing their interests as they determine. It is not our role as attorneys to substitute our judgment of what we believe is in the client's best interests, and it is a violation of our duties to report to the judge what we believe is in the client's best interests, contrary to the stated wishes of the client. Thank you.